All right. Good afternoon, everyone. On behalf of our director, Michelle K. Lee, and as of 2 days ago, our new Chief Administrative Patent Judge, David Rushke, I would like to thank the Korean Institute for Intellectual Property and Commissioner Choi of the Korean Intellectual Property Office for the invitation and providing the U.S. Patent and Trademark Office the opportunity to speak with you today. So I'd like to start, if I may, on a personal note. I am American born and raised, but I am of Korean descent. My father's side comes from a long line of engineers. My father served as the director of the Hyundai Maritime Research Institute, and my mother's side has a long history in law. My grandfather was vice mayor of Seoul, and my great-grandfather was a Supreme Court Justice of Korea. So personally, it's a great honor to be representing my country in my ancestral homeland. So I was asked to speak about our operations concerning inter-parties reviews and post-grant reviews, which I'll call IPRs and PGRs from here on out. In that regard, I was asked to focus on how we handle submission of new evidence, and generally I'll note that as our reviews are only 4 years old, we at the PTAB are still very much in the process of learning how to conduct these reviews in what I will shorthand as the 3 pillars of justice. We want the reviews to be timely, we want the reviews to be cost-effective, and most importantly, we want the reviews to be correct. And so to that end, I think a brief discussion of the history of invalidation proceedings in the United States of issued patents would be helpful in understanding how we arrived at what we have today. So if you'll look at the slide, for most of U.S. history, once a patent issued from the PTO, the only way to invalidate that patent was through district court proceedings. As we progressed through time, however, the sense of the public was that invalidating patents in this way took too long, usually on the order of 2 to 3 years, and cost too much, usually a minimum of about $1 million, most of that usually being discovery costs. So in 1980, the Bayh-Dole Act created ex parte reexaminations to be conducted in the PTO. The thinking was that you have these technically and legally trained individuals at the PTO, and that expertise could be leveraged in a way that could still be correct, but be a more timely determination of validity, the goal being to take no more than 2 years, and in a more cost-effective way, as there is no discovery in ex parte reexaminations. For the most part, ex parte reexaminations were not used by the public, primarily because a third-party requester could only suggest reexamination, but then couldn't participate any further. And we heard that many third parties didn't like that feeling of not being in control. So in 1999, the American Inventors Protection Act created inter partes reexamination, and this allowed more participation by third-party requester. Again, however, these examinations generally proved unpopular, in my view a bit ironically, because third parties decided that they actually wanted some aspects of discovery, such as cross-examination, especially when they were going to be subject to the proceedings' estoppel effects. So this brings us to the American Invents Act of 2011, where IPRs and PGRs were created. And you'll sometimes hear about a certain type of PGR proceeding called covered business method patent reviews, but for our purposes, I don't really need to go into that. So IPRs and PGRs, what are the benefits of this system with respect to district court proceedings? Well, the first major one is time. As you can see on this slide, by statute, the entire process from start to end is supposed to take no more than 18 months, so faster than the 2 to 3 years in district court. And the most relevant points on the timeline are the beginning, the filing of the petition, 6 months after the petition is filed where the PTAB decides whether or not to institute a trial, at 9 months when the patent owner files its response to the petition, and at 12 months when petitioner files its reply, and at 18 months where the PTAB issues a final written decision on all instituted claims. Another benefit is cost. So the PTAB has promulgated rules such as limits on motions and pages to hold down costs to the parties wherever it can, but without sacrificing accuracy. And to address a perceived shortcoming of inter-parties reexaminations, the statute of legislative history gave us express instructions to permit discovery, but also to keep it limited to only that which is necessary in the interest of justice or good cause, depending on the proceeding that it is. Which gets us to evidence. So obviously the whole challenge here is that we're trying to evaluate a large amount of evidence in a short period of time. So what are some things we did to help everyone out here? Well, One thing we did is we required the petitioner to put almost all of their evidence up front in the petition and put the initial burden on them to show us why a trial should be held. So right at the start, we can focus the trial because we know exactly how the petitioner wants to apply the prior art to the claims, and now we can just have a discussion as to whether or not they are correct. And of course, this does not work if petitioner is later allowed to add new evidence and effectively shift the focus of the trial, which would of course consume more time and more resources. So in general, the short answer is we don't allow the petitioner to add new evidence, and most significantly in the replies. And a good discussion of the reasoning as to why, it is in a Federal Circuit case that actually came out just a few weeks ago, and so I apologize for not being listed here, but the case in question is Intelligent Biosystems v. Illumina Cambridge. Now at this point, however, I like to add a very big caveat that we do allow a petitioner to add new evidence for things they couldn't reasonably foresee at the time the petition was filed. Most prominently, whether patent owner would rely on evidence of secondary considerations, or if a patent owner decides to file a motion to amend. Probably the best overall discussion for our reasoning for being so restrictive on new evidence in these proceedings can be found by reading this decision from the Federal Circuit, Red Line Detection versus Star Envirotech, which talks about our standards concerning supplemental information. So moving on, I was asked to discuss whether there was a difference in standards of unpatentability applied to the PTAB and in district court proceedings. The short answer is yes, but the difference really is more between an issued patent in a district court proceeding and then really everything else. So for anything else not involving an issued patent in a district court proceeding, a preponderance of evidence standard is used. The primary reasons for that being, one, we don't have an issued patent yet, and or the patent owner has the opportunity or chance to amend the claims. For an issued patent in a district court proceeding, however, the standard for unpatentability is clear and convincing evidence. And the main reason for that is that in an issued patent in a district court proceeding has a presumption of validity conferred on it by statute, and because it is assumed that the PTO has done its job when the patent was issued. So feedback, how are these IPRs and PGRs viewed? Well, like anything, it depends on who you ask. So by the numbers, petitioners largely appear to be in favor of them. As you can see on this chart, before implementation, it was estimated that about 500 IPRs and PGRs we filed annually, but in each of the first 2 fiscal years of these reviews, 3 times as many have been actually filed, and we're on a similar pace for this fiscal year. Patent owners, however, have not been as positive, which I don't think is really surprising, given that there really isn't much upside for them, as really the best possible outcome for them is the status quo. There have been a host of criticisms about IPRs and PGRs by patent owners that are winding their way through the courts. And 1 month ago, the Supreme Court heard arguments in that last case listed on the slide, Quozo. A decision there should issue by the end of June. For district court judges, these proceedings are most relevant to them in that they have the option of staying their district court proceeding while the IPRs and PGRs are contemplated by the PTAB. Listed here are some of the benefits of such stays opined on by at least one district court judge. But anecdotally, I have also heard some criticism, mostly related to partial institutions, as well as the claim construction standards. Of course, everything we do is reviewed, and IPRs, PGRs can only be reviewed to the Federal Circuit. The legislative history on why that is the case is actually rather thin. So here I have cited HR report number 113-279. So this involves a discussion in Congress of essentially repealing the option to appeal examiner rejections to district courts instead of the CEFC, what we call 145 actions. I would think those same arguments would apply to statutes limiting IPRs and PGRs to Federal Circuit review, and I have presented a subset of those arguments on slide 24. For CEFC appeals of IPRs and PGRs, I'll leave that discussion to my colleague, Associate Solicitor Amy Nelson, who is scheduled to speak later today. Now, of course, as I stated earlier, these proceedings are still very new, so we are constantly trying to improve. The most immediate way this is done is through our orders and decisions that we issue on a daily basis, some of which are precedential and informative, and some of which I've laid out here. We also more recently designated 5 decisions as precedential on a variety of issues, again to provide some guidance to the patent bar and the public. We also strive to improve by updating our rules, and although no current effort is currently underway, we had actually just completed a 2-year rule change process, which ended with the final version on April 1st of this year. And of course, there are many variations of legislation in Congress that could affect our proceedings, and I've listed one of those bills here. And that's pretty much it. So thank you for your attention. Thanks again to the Korean Institute for Intellectual Property and the Korean Intellectual Property Office for the opportunity to participate. And I hope you found the presentation useful.
박수 부탁드립니다. 마이크 김 심판장님 좋은 발표 감사합니다.